Oh, I just wish I had more time. Oh no.
Well, let's do this. This is the case of the State of Ohio versus Kayla Severs, case number 25 CR 43062. Present before the court is Ms. Severs, right?
Severs.
Severs, all right, Ms. Severs, represented by Mr. Staten, and we have Mr. View from the prosecutor's office. We are here today for a pretrial. Mr. View, what's our status?
Your Honor, the state made a plea offer in the case just about a month ago to Ms. Severs of a plea to reduce count 1 to a third-degree felony trafficking in fentanyl-related compound. We do a PSI as an open sentence. The state would leave the sentence to the court and dismiss counts 2 through 9. Today, Ms. Severs is formally declining the state's offer on the case, and we're setting it for trial.
Mr. Staten, what's our status?
Your Honor, I believe that is the same. I believe that is all accurate. My client would prefer a little more time. The discovery was voluminous. We had to track down some other work records and things to see what potential defenses were available to her. I've explained to her, and I've talked to Mr. View about that. The state is not willing to continue their offer for another pretrial. And so at this point, she has decided to decline the offer.
I mean, the essence of the case is not going to change, right? I mean, we have all the discovery exchanged. It's just the decision that needs to be made, right?
It is, Your Honor. And I will tell the court that there's some custody issues and questions about how, a conviction would affect that regarding her minor child. It's not directly involved with this case, but that is what is causing her consternation at this point.
Okay, so the reason that I put these discussions on the record, Ms. Severs, is because this is a critical moment in the case. You're charged with a couple of different charges, but the two charges that are the most significant are the trafficking in drugs and the possession of drugs on the 2 separate days, because those carry with it mandatory prison sentences. That means if you are convicted of those, the court has no choice but to sentence you to at least 2 to 3 years in prison. When I say 2 to 3, 2 is the minimum with a possible indefinite sentence of 3 years. So I have no choice. If you are convicted of these offenses, you have to go to prison, and you have to go to prison for no less than 2 years. The offer from the state is for you to enter what is called an open plea to a third-degree felony. That means that there is no mandatory prison in the case, and that I could sentence you to something less than that. Generally speaking, somebody with no criminal history who is not directly involved in the hand-to-hand sale of these, it's my understanding, based on our pretrial discussions, that you were mostly accused of just being the driver. If that is in fact the case, then I would probably not impose a prison sentence, and you would still be looking at probably some amount of local time based upon, when I say local jail time, based upon what I know now. I know these are big and weighty issues, but at some point we have to decide how it is that we're going to move forward. We all have our roles in this process, Ms. Severs, and my role is to preside over the case. My role is not to determine what you are charged with or what plea offer is available to you. That is Mr. View's role in this process, and he is the one who controls whether he makes an offer or not, how long it stays open, and all of those sorts of issues. I don't have the ability to tell him, hey, you need to leave your offer open a little bit longer. Do you understand all of that?
Okay. I do though. I really feel like I need to tell him something. The thing that I'm concerned about, one, I've never been in trouble. This is new to me, so all of this is a lot. Two, it's my daughter that I'm worried about. They're stating if I get any type of time, whether it be jail, prison, it doesn't matter, any type of time other than probation, she's being taken away from me. That's what I'm worried about. So I just don't know what to do. I don't know what to do. I'm sorry.
Ms. Severs, I don't want to seem unsympathetic to your situation. I understand that this has significant consequences, but these are very serious charges.
Oh man, I don't know what to do.
But it's also my understanding that, if I were to give you, let's say we were to set this for another pretrial, even in 2 weeks, the basic decision that you have to make, whether or not you are going to proceed to trial, it's not going to change. And you're not going to get any additional information about what's going to happen with your child or what's going to happen at trial or any of the, we're not going to push the ball forward in that regard. You're still going to have the same terrible decision in front of you, whether it's we make that decision today or we make it in 2 weeks or we make it in 10 weeks. It's not that the basics of it is not going to change, right?
Okay. Oh, I just wish I had more time. Oh no.
Well, let's do this. We got some other stuff that we have to take care of on the docket. Mr. View, you're around this morning, right?
I am open this morning, Judge, yes.
So why don't we do this? Mr. View, if you would be kind enough to extend your offer for an additional half hour. So we'll have a decision by 10:45, and we don't need to come back on the record to do that, Mr. Staton. You just let Ms. Kuroko know. You don't have to stay around here, Mr. View. You can go back up to your office. We'll call you. We'll either set it for trial or we'll get some plea paperwork done and we'll go forward with the plea. That way, we'll have some resolution today and we can all get back to the other things that we got going this morning.
I did print out the plea form, so I'll leave it here on the table if Mr. Staton needs it.
Thank you.
Okay, and then just let Ms. Kuroko know. But if we haven't heard to the contrary, by 10:45, we're going forward on a couple of F2s.
Understood.
All right, that's
Thank
all.
you.
Thanks, Judge.
We are back on the record in Ms. Severs' case. It's my understanding Ms. Severs is going to be entering a plea of guilty to 1 count, trafficking in a fentanyl-related compound, which is a felony of the 3rd degree. Is that accurately stated?
It is, Your Honor.
Ms. Severs, how old are you?
31,
How far did you go in school?
10th grade, I believe.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
I just had major surgery. My thyroid was removed because I had cancer. So I'm on thyroid medication now.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what we've talked about in this courtroom today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line Defendant. Is that your signature?
Yes, sir.
Would you review this with Mr. Staton before you signed it?
Yes, sir.
Are you satisfied with the representation that you have received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of trafficking in a fentanyl-related compound. This is 3rd-degree felony, punishable by up to 36 months in prison and a $10,000 fine. Also carries with it a mandatory fine in the amount of $5,000. And if you violate the terms of your supervision and I send you to prison, it also carries with it an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, or this charge, you're going to waive all of those rights, you're going to admit that you did it, we're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on July the 18th of 2025, at a location in the city of Franklin, Warren County, state of Ohio, that the defendant did aid and abet Curtis Everhart in the delivery and offer of sale of 11.9 grams of what was later tested to be fentanyl-related compound.
Mr. Staten, anything on those facts?
No, Your Honor.
Ms. Severs, did you hear those facts?
Yes, sir.
Do you admit that they are true?
I'm sorry. So do I plead guilty even though I'm not guilty? If I'm taking the deal, is that how that works? Like I have to say I'm guilty?
Well, you're not gonna lie in court. Your Honor, would the court accept a no contest plea on those, or
Like,
we have to talk about an
I'm
Alfred plea?
sorry. I'm just confused. Like, I don't know how none of this works. So if I take the plea, but I still feel like if I am saying I'm not guilty, but I want to take the plea over taking it to trial, do I still say not guilty, or I have to say guilty to take the plea?
There is a special set of circumstances for that, Ms. Severs. It's what we call an Alfred plea. It's not a no contest plea, because a no contest plea means that you agree that whatever Mr. View just said was the truth, but you don't necessarily agree that those facts constitute a criminal offense. That's not what you're doing. What you're saying is you don't agree that the facts that Mr. View read into the record are true, but what you do want to do is you want to accept the plea offer and not take the consequences that might follow by going to trial. That's called an Alfred plea, based upon a United States Supreme Court decision that says that you have the right to plead guilty to charges whether you did them or not. So if you want to enter an Alfred plea, that's a guilty plea. So that is a guilty plea pursuant to your agreement with the state of Ohio today. So you're entering a guilty plea. I just have one additional step, which is that after you enter your plea of guilty without admitting to those facts, I will ask Mr. View a couple of questions about what his case would have looked like if we would have taken the matter to trial, and I have to make an additional finding that there is substantial evidence of guilt. Do you understand that?
That makes sense.
Yeah, but that's just also confusing.
Well, you plead guilty. Could say that's not true, but I'm gonna take this plea anyway, because I'm not gonna roll the dice, I'm doing mandatory time. And then the state will explain the circumstances, and the judge will accept your guilty.
I don't know if that's gonna affect what. I don't know how to do any of this.
Well, you know, it's pretty simple. You say, that's not true, but I'm gonna take this plea anyway. That's basically what you'd be saying, right? Is that what you want to do?
Yeah.
Okay, you sure?
I don't know.
But that's what we want to do, right? I mean, that's our plan here. Is that, so you would enter a plea guilty, but say, well, those facts aren't true, but I'm still going to enter a plea guilty. That would be an Alfred plea.
I'm just gonna say I'm guilty. I don't know. I'm just gonna say I'm guilty.
Okay, that's not the question that's being posed to you yet, Ms. Severs. The question that's being posed to you is, Mr. View read some facts into the record that said that you aided and abetted Mr. Everhart in the trafficking of drugs. Do you admit that those facts are true?
No.
All right. Do you understand the rights that you're giving up by entering a plea of guilty to this charge?
Yes.
Is this what you want to do?
Yes.
What is your plea?
Guilty.
Mr. View, what would the cases have looked like had we had a trial?
Your Honor, if we were to proceed to trial, the state would call as a witness in the case Detective Greg Spannell of the Warren County Drug Task Force. Detective Spannell would testify that he was in contact with Curtis Everhart and arranged for the sale of fentanyl at a location at 6830 State Route 123 in the city of Franklin, Warren County, state of Ohio. And he, in direct contact with Mr. Everhart, arranged for that sale. Detective Spannell arrived at the buy location, and Mr. Everhart contacted him just to confirm which vehicle he was driving. The driver of the vehicle then approached Detective Spannell's car, was driven by Miss Seaver. She was identified through surveillance as an associate of Mr. Everhart, that they resided together, and the vehicle that was being driven was also registered to Ms. Severs. Mr. Everhart then, once the vehicles pulled up even, got out of the vehicle, got into Detective Spaniel's car, where they engaged in the sale of fentanyl, what was later tested to be 11.9 grams of a fentanyl-related compound, as tested by Haley Balzer, criminalist, who would also be called as a witness. Mr. Curtis Everhart then, following the transaction, returned to the vehicle driven by Ms. Severs, who drove away.
All right, the court finds that there is substantial evidence of guilt. I find that the plea has been made in a knowing, voluntary, and intelligent fashion only after Ms. Severs had been fully advised of her constitutional rights, which she waived and rejected here in open court, and I am going to find you guilty of this offense. We're not going to go into the matter of the sentence today. You're going to go back down to pretrial, fill out the paperwork for the PSI. We'll do a level 2 pre-sentence investigation. We'll see everybody back here in about 8 weeks. Anything else?
No, Your Honor, thank you.
Your
All
Honor, my client's currently on electronic monitoring. She has been compliant, she has no record, and she turned herself in once she learned that there was a warrant out. We would ask the court to consider modifying that to remove her from electronic monitoring.
Stay in position on that, Mr. View?
No, Your Honor.
All right. I don't have a problem taking her off monitor today, so I'm going to do that. Go back down, Community Corrections. We'll also get an email letting them know that you're coming off the monitor today. You are going to be converted to pretrial, so you'll have that additional hoop to jump through. All right, that's all.
We have a pretrial person working with.
I'll send the email, Ms. Kuroko.
Your Honor, my client's car is still being held. I don't know if it's being held as evidence in the other case or in this case. The court want just a written motion to release that, or? just leave it
Yeah,
up to them?
I would need a written motion because Mr. Everhart's case has not yet been resolved. I don't know if it has evidentiary value or not, but we have to figure that out, so file a written motion.
Will do.
Because I'm going to pay it off today, and
It's okay,
that's,
it's
that's
okay.
my only transportation.
I understand. We just have to do it in writing, so the state can get that.
Thank you.
Sure, if there's